Jessica Salaji, your host. In this episode, we're going to take an angle that's a little different than things that I usually cover, and we're going to talk about something that's technology related. It's quite the conundrum, though, because it hasn't really, it goes between the proper role of government and the individual liberty and where those lines meet when it comes to technology. And it's something that the courts haven't really worked out yet. Just recently, the Arkansas State House voted to ban employers in the state from requiring their employees to be implanted with a microchip. The vote was 84-4 to specifically prohibit requiring an implant as a condition of employment. For those of you who don't know, microchipping is an implant of a microchip under the skin, and it's used as a means of identification. Right now in the United States, this is something that's primarily used in cats and dogs, and it's usually the size of a grain of rice, and they put it in your hand, usually between your thumb and your index finger, with a syringe. The fact that this is something that's used primarily for the tracking of animals is one of the reasons that the conversations about these microchips and the technology that goes with it goes from 0 to hysteria in 2.5 seconds. They were created with livestock and domestic animals in mind, so I won't dispute some of the concerns with you fine folks with the tinfoil hats. I wear one sometimes as well, but I want to have a discussion about the bill itself, and then we'll go into privacy concerns and where this is going and what kind of precedent the Arkansas House is setting with this, because they are the first state to kind of spearhead this and make any movement with it. Specifically, the measure in Arkansas, which is sponsored by Republican Stephen Meeks, would only allow microchipping if the employee gives written consent, and employers would be responsible for the cost of implanting, the cost of removal. They would be responsible for any health problems caused by the chips. Whoa. How can you prove that? And of course, the companies have to disclose how they're using the data that's collected with the chips. So at face value, I'm going to go out front and say it seems wrong that we're prohibiting businesses from doing anything. It also seems duplicatively wrong to be codifying what businesses must be responsible for paying for, being the implementation or the removal. And it seems odd that we're putting into law that someone must give consent for something to be done with their body. It's even worse that we're talking about a state creating a privilege for businesses by the way of a bill saying, you can do this, you can offer this type of technology at your place of business, just not against anyone's will. Obviously, that is quite literally what freedom and individual liberty are all about. Consent, individual rights, property rights, being in control of yourself. So the fact that we're saying consent is mandatory in a law, we already know that. But so after listening for only a couple of minutes, you're probably wondering, where are we going with this? Is this not the proper role of government? That's kind of how I approached it at first too. And if your libertarian principles are in check, you're asking, why do we need this law? But this is one of those issues where I kind of want to work my way through it and see whether or not this is one of those times that a legislative body is ahead of the game. And if it isn't, we'll just remark about how incredibly wrong they are, like most of the time most of our legislators are. But either way, we've learned something, and that's what this podcast is all about. So back to the story in Arkansas. I've already decided collectively for us that what the legislature is doing there and how they've chosen to do it is neither correct nor proper as far as the governmental role goes. It seems premature too, because no company in the state has said, oh, we want to microchip our employees. Not voluntarily, not involuntarily. No one has said that. The sponsor of the bill, Stephen Meeks, said, quote, "The idea here is to set the ground rules before the technology comes to our state to protect workers. Do we wait until after the snake bites and then try to come up with solutions for it? I believe there's great wisdom in doing it beforehand." That is a direct quote from Mr. Meeks of Arkansas. So, Stephen, first of all, you're wrong. Second of all, you're quite literally creating a solution for a problem that doesn't exist. And third, there are already plenty of things in the state, in every state, that protect workers and individuals. It's called the Constitution. But if this was just a black helicopter conspiracy theory-esque piece of legislation spearheaded by a Lone Ranger, I have a hard time believing that it would pass overwhelmingly 84-4 and so quickly in their legislative session. So I know you'll be shocked to learn this, but I did a little digging. And Meeks is chair of the legislature's technology committee. And chairmen generally are political players. They work their way up. They hold power. They are influential. And as chairman of the technology committee, he found that there are no state laws to regulate the implants in the U.S. He wants to be the first. If you were sitting next to me right now, you would see me waving a red flag. Red flag, red flag, red flag. A politician seeking to do something because they want to be the first is not only egotistical, but it makes for bad policy. Most lawmakers won't go against a chairman because, principles and party loyalty and all those things. So whether or not something makes its way out of a committee is not a good qualifier for the quality of the legislation. What I think happened, and I'm speculating because I don't live in Arkansas, but I'm speculating that the 84 yay votes were a case of the look at me's, let's get the glory of spearheading something, let's be first in the country to do this. Honestly, I'm surprised that they didn't take a simpler approach and approach this not from a technology standpoint, but a HIPAA standpoint. It seems that would be more simplistic, more realistic, and it would actually address what most critics of microchipping or RFID chipping say, in that it's a privacy problem. But when I say all this is premature, it really is. As of January 2019, the instances of microchipping in the United States are extremely limited. First of all, Wisconsin is the only state that really has a business that's doing this. 3 Square Market in 2017 announced that employees who agreed to have a chip implanted They agreed. That's voluntary. If they agreed to have one, they could use it to open doors, buy break room snacks. All they had to do was wave their hand. 80 employees opted in. But as you notice, the state didn't enact a law to grant businesses the privilege to do something voluntarily with their employees. Also, the cost side of this has me wondering how many companies would actually be think this would be the most efficient way to do something, aside from key cards or anything else that is way lower in cost compared to implanting a chip in somebody. But these chips, they're, like I said, they're about the size of a grain of rice, and they cannot track location yet. Keyword is yet. Yet. Technology's ever evolving. But these chips have been around for 70 years. Not necessarily the chips, but the technology. And they use radio waves to detect, identify, track, and manage chips that are nearby or far away. And the technology transmits data from the chip to a stationary reader. So it could be in a break room or an office entryway. And it's kind of like what they use for toll collectors on a car windshield for toll roads. So what's interesting here is that there's some Milwaukee attorneys who, I think Sarah Platt and Keith Copeland were the names. They wrote in an opinion on this that depending on where the access points are installed, an employer can gain useful information, such as how long an employee spent in the break room in the same vicinity of another employee who has alleged harassment, or when material went missing. So they can kind of connect dots, but it doesn't technically have a GPS tracker, which is a lot of concern for people, but the technology doesn't seem to be there yet. But these companies that choose to use microchips on their employees have to be prepared to handle personal privacy complaints, security lapses, workers' compensation complaints if there is an adverse reaction, which I still think is hard to pinpoint on a chip, but they can cause medical complications. And then the need to make medical and religious accommodations if chips become mandatory. So back to legislation and the proper role of government of it. In Nevada, in 2017, State Senator Becky Harris introduced a bill to prohibit forced microchipping in people, but she had a little bit different angle. She said that the idea is not far-fetched because it's already happening in places around the world. She introduced Senate Bill 109, which would have made it a Class C felony to require someone to be implanted with a radio frequency identifier, which is RFID, and like the ones placed in pets. And her idea came from a constituent that told her about a company in Australia that made thousands of implantable chips with do-it-yourself kits. They cost just $100, and they included a tag and a tool to do it yourself. And so her angle was the criminal side of things, to either force someone to do it in a company or to do it without their knowledge. I can at least understand this aspect because you're imposing a penalty for doing something against someone's will. That's legitimate, more legitimate than what Arkansas is doing, meddling in between a private contract. But of course, the legitimacy side of things didn't go anywhere, which is why Arkansas is back at the forefront wanting to be first. This technology, this Miss Harris from Nevada said that it's something that's used all over the world. I don't know if that's accurate. I don't think it's as popular as people think. I think it's becoming more and more popular. But Sweden is definitely a country where microchips have already replaced the need to carry keys, credit cards. They're used to get train tickets. It's very common. But that's just Sweden. So let's go back to the United States. Let's say a company did want to require a microchip as a condition of employment. The employee has two options. One, they can quit, or two, they can sue. Employment is a private contract between two parties, both of which who can cancel at any time. No one is requiring you to continue to hold a job under conditions that violate your beliefs, your standards, or your desires. So quitting seems optimal. But if you don't want to quit, you can sue them. You can bring a civil suit. All of this can happen without a new law. So I'm failing to see why the state of Arkansas is getting involved at all. Why does the state have to pretend like an employee doesn't already have the right to consent to having something inserted in their body at a voluntary job? I've been rambling about what Arkansas has done, but there were a couple people who were against the bill. And so I want to read you this quote by Representative Mary Bentley. She said, "I don't see why we need to get into this at all. The free market's already handling it." And she's right. Someone should buy Mary a craft beer or CBD oil bath bomb because she's right. The market is already handling this. If people don't want to adhere to the job description or the job requirements, they can go find a job somewhere else. To be clear, I oppose the use of microchips because I think the risks outweigh the benefits. I don't necessarily oppose a company requiring it because I think that if that's what they want to do, they should be allowed to do that. I don't think people should be forced to do this from a criminal, like we're talking about in Nevada. I think that if someone is done against their will or anything like that, there should be criminal repercussions for that. And if the law needs to be tweaked so that that can be a criminal offense, then I think we should do that. Personally, there's not a snowball's chance in hell that you'd catch me with a microchip in my hand or anywhere else in my body. It wouldn't matter who I was working for, or how short it would make checkout lines, or how it would limit what I lug around in my purse. I think it's creepy. The few seconds you shave off of life from typing passwords and swiping cards and putting dollar bills in vending machines isn't worth the trade-off of losing privacies and compromising personal data. But that's just my opinion. Ain't nobody chipping me, but that's just me. But when I say all that, it gets me thinking about the fact that nobody's really talking about the privacy aspect of this. I mentioned HIPAA as an integration way instead of doing it the way they're doing in Arkansas, but true protection would deal with privacy. Instead, these lawmakers are actually pretending that demanding a private company disclose how and what data they're collecting is in the best interest of the employees and the people in general. But think of how easily your credit card numbers and our driver's license numbers and social security numbers and everything else is hacked. I mean, Equifax, which is supposed to be a protector of our data, was hacked. Like, we hear of this all the time. And no, you can't steal an identification from a microchip, at least not yet, but you can mine the data that's collected. It can be stolen. That's why there's RFID blocking wallets and devices to keep scanners from gathering information from credit cards and the information we're already carrying around. And here's another question for you. Who owns the data on a microchip? The company, because they're paying for it? What if you opt in to pay for your own? Can you own the data? There's no rules for this. And what about our beloved court subpoenas? When will the data of a microchip be subject to and protected from searches and other Fourth and Fifth Amendment things? These are questions we should be asking instead of limiting what a private company is doing. Mr. Meeks in Arkansas should have been restricting what the government can and cannot do with this information because that's the proper role of government. That's a lawmaker who's for the people. But that isn't what's going on here. The government has once again meddled where it shouldn't. And for what? The reality is that the government's role is not to be proactive. It's important that our lawmakers be reactive on things like this so they can ensure that they are crafting legislation that actually addresses a problem. We don't need a solution for a problem that may arise. That's not good governance. The reality is that the role of technology and the role it plays in our day-to-day lives is only going to expand, and we need to think first and act second, not the other way around. observe, determine who the victim really is, and ask, why does the government need to intervene? And much to the dismay of Representative Stephen Meeks, the answer is not ever going to be first. This is going to continue to be an issue. And I think what they've done here is open the door for what government's going to have the right to do and how government can use these things. Think about foster children. Think about Alzheimer's patients. Think about the military and those killed in action and how these things would help identify people. And if you put in place that it can be done voluntarily, but you don't have privacy protections and you don't have any type of thing that protects people from a collection and Fourth and Fifth Amendment right perspective, this is just going to be one of those things where we give up essential liberties for safety and security. And that's not a black helicopter tinfoil hat thing. That's a reality. It doesn't matter if it's happening involuntarily or voluntarily. There's nothing in place to protect our privacies. These things have not been identified in the courts. They have not been identified in state law or federal law. There is nothing that says what happens to that data when it's in our bodies and who's the owner of it. If states want to be prepared for things like this, they should craft legislation to constrict the government, not the people. That's the great thing about a limited approach to government. It's always applied the same, regardless of technological advancements and what issue we're talking about. Don't you agree? I know you agree. I always love hearing from you, the good, the bad, the ugly, the neutral. You can drop me a note on social media where I hope you're already following me. Facebook, Twitter, Instagram, YouTube, all of them. Until next time.